In Szwed versus Aviva Insurance Limited, Mrs. Justice Hill dismissed an application to reinstate two struck-out appeals arising from costs budget decisions made in ongoing personal injury proceedings in the Central London County Court. The recorder had permitted the respondent insurer to increase its approved costs budget by £27,000 against a sought increase of £31,611 to reflect costs of surveillance evidence, medico-legal examinations, and interpreter attendance. The appellant, a litigant in person, subsequently applied before His Honour Judge Hellman to have the respondent's budget reduced to nil on grounds of oppressive conduct, an application the judge dismissed, doubting that any such power existed and preferring the respondent's evidence that delays in the joint expert process were attributable to the appellant. Both appeals were struck out automatically following non-compliance with an unless order. Applying the Denton three-stage framework, as directed by R versus SSHD, Mrs. Justice Hill held the breach was serious and significant, the reason for default unpersuasive, and the merits of both appeals very weak. The costs budget decisions were case management decisions, attracting a high threshold for appellate intervention under Royal and Sun Alliance Insurance plc versus T&N Limited, and Practice Direction 52A paragraph 4.6 further militated against permission. Both appeals remained struck out. Quote, "Third, the judge's dismissal of the appellant's applications to have the respondent's cost budget reduced, ideally to nil, on grounds of its oppressive conduct, was again a case management decision. It was a highly unusual application. As the judge identified, it is far from clear that there is a power to make such an order. In any event, the judge was entitled to accept Mr. Wright's evidence, not that relied on by the appellant, which sought to explain the delays in the joint expert process, so as to refuse the application."
For a detailed summary of this decision, visit tmclegal.co.uk.